Mad Dad here with information for parents that are dealing with the other parent constantly violating the custody and visitation order. Now, the parent who's I would consider like the victim of the other parent violating the court order may have went to court off a request for order and to let the courts know about the other party violating the court orders, and the judge or commissioner does absolutely nothing other than tell the other party to obey the court orders and do what's instructed. Okay, and you leave court with the same issues that you had going to court, and nothing's ever resolved. Now, for those parents who've done that, don't go that route again. Okay, you ain't gonna get nowhere. All right. Instead, what you do is you file a contempt of court, on that ass. Okay, you go ahead and you file a contempt of court, and more than likely, you're going to get you're going to get your day, and you're going to be heard the right way. Okay, now for those of you that don't know, okay, you have to. It's important, and you have to understand that both parents are ordered to follow the court order to the T. Okay, unless both parties mutually agree to go outside of the court order. But if there is a breakdown and the parents decide not to agree on exercising other visitation and custody, you guys don't mutually agree, then you guys have to go back to that court order, what's in black and white. Okay, so if you're finding yourself and the party is not doing it, give me 1 second. I'm gonna pull up some notes real quick. And the party is not following the court order, you file a contempt on that ass, and you're gonna get some resolve, like I said earlier. Okay. Now, a contempt of court. I'll give you a little information about this. A contempt of court is very serious. Okay, it's a very serious thing. Basically, in my opinion, okay, only in my opinion, it's like a criminal matter that is heard in a family law court. Okay, the alleged person, the alleged parent of violating these court orders, they are entitled to their due process. What this means is that they have the right to be formally notified of all charges. Okay, it's not these things they call charges. Okay, each time, each count that you violate, it's a charge. Okay, and the parent is entitled to be notified of those charges. The parent is also entitled to having the right to counsel. Okay, so the judge or commissioner will appoint either a public defender, or that parent may be able to go out. Will be able to go out and hire their own private attorney if they deem it necessary and they want to or can afford it. Now, this is the thing about it. Last thing is that the last thing is that not only do they have the right to counsel, they also have the right to have their hearing heard, have their case heard on the matter, have a hearing on that matter, have a hearing basically to have their case heard about their violations. Okay, now before filing a contempt of court, you must make at least 3 things clear. Okay, in regards to your case, you must make sure that the order that you're talking about is valid. Okay, it's an enforceable order, which you guys both should be following it. Okay, another thing that you should make sure of is that the court order is not only valid, but man, what do I want to say? It's valid. The other parent is aware of the court order. Okay, the other parent either was in court during the same time, received the documents after the hearing, received what they certified findings in order after hearing, something. They had to be aware that the court order existed. Okay, and the third thing is that you have to show that the parent intentionally violated that court order. Okay, so what you should do is, so prior to even approaching the court, wanting to file a contempt of court, you must make sure those 3 things: that the other parent knew, that the order was valid, the other parent knew of the order, and the other parent intentionally violated the order. Those three things. If you can prove those three things, then you should move forward, with filing the contempt of court. Now, the thing is that because the contempt of court issue is so serious, it is highly suggested, okay, that you go and get yourself an attorney to handle this issue, okay. But you want to save costs. You want to save costs, and there's attorney fees and court costs and whatever the case may be. So you can do something like fill out the fee waiver with the court, see if you can get payment plans or something. I think the filing is maybe, in California, it's about maybe between 90 and 120 bucks or something like that. You should be able to afford that. I don't care. Go out on a day and collect cans, come up with the money, okay? I think it's like 33 cans equals 1 pound. Trust me, I know, because a brother used to do that. Okay, so anyway, you want to go. The best way you will want to go about it is the most cost-effective way, and you want to hire an attorney. Let me get back to that. You should, if you can, find someone, a paralegal, legal document preparer, somebody in the family that knows how to prepare legal documents. Prepare your paperwork yourself. Okay, or prepare it with to save on costs. All right, you prepare the paperwork yourself, get it approved, submit it to the court, see if it's approved. Okay, once it's approved, then you go ahead and hire an attorney on limited scope. Okay, on limited scope basis, hire an attorney on limited scope, and it will be much cheaper. Okay, then you retain an attorney. Okay, now retaining an attorney and hiring an attorney on limited scope, two different things. Okay, so it involves two different forms that you submit, to the court, and to get that you have to file with the court. But anyway, you hire an attorney, and you go into court in regards to your in regards to your contempt of court. Now, the reason why I'm saying, again, that you need to hire an attorney is because it's very serious. And like I mentioned earlier, the other party is going to be appointed a public defender or going to be able to hire their private counsel. And that private counsel or that public defender is going to go against you. And if you're not legal savvy, even if you are, okay, if your emotions are involved and all this other stuff, then you know what? You need to hire an attorney, because that public defender or that private attorney is gonna eat your ass up. Like, seriously. Oftentimes they will try to, they'll want to try to, see if you guys can meet and confer and to negotiate a settlement. But if you take it to court, it's gonna be something nasty if you don't have the know-how, and if you don't get an attorney to do it. Okay, but pretty much that is it. Now, what do I want to say? I pretty much don't want to say anything else. Okay, I hope you found this information helpful. I hope you use this information to better your relationship with your child or children. If you did find it helpful, please like, share, donate, do whatever you can to help me continue to share this information. That's pretty much it. Okay, so until next time, you have a good one. Bye now.